My name is Bhargavi Kumari, and I'm honored to welcome you all to the second session of the day. The topic for this session is procedure and administration proceedings, both contested and non-contested. The speaker for this session is Advocate Tejas Vora. Tejas Sir holds an LLB degree from Government Law College, Mumbai. With over 40 years of experience practicing as a lawyer in the Bombay High Court since 1984, Sir brings both deep legal knowledge and practical insight into the procedural nuances of estate administration. His practice spans civil and commercial matters, and with his extensive experience in both contested and non-contested testamentary cases, he will help us bridge the gap between theoretical understanding and practical legal application. I now request Dr. Nilima Bharbade to kindly felicitate Tejas Sir. Thank you, ma'am. Today's session will cover the procedural aspects of testamentary succession, including obtaining probate, letters of administration, succession certificates, and heirship certificates. As part of this, we will explore key aspects of the procedural journey, including who can apply and who can object, which courts have jurisdiction, and what are the court fees, what are the documents and evidence required, and who bears the burden of proof, how are interested parties notified, and what are the modes of notification. For this session, the following provisions will be particularly important. Chapter 4 of Part 9 of the Indian Succession Act, covering sections 264 to 302, which deals with probate and letters of administration. Part 10 of the Indian Succession Act, covering sections 370 to 390, which pertains to succession certificates. Bombay Regulation 8 of 1827, which consists of 11 sections pertaining to heirship certificates, and Bombay High Court Original Side Rules, specifically Chapter 26, that is sections 369 to 444. This is because Section 300 of the Indian Succession Act provides that the Bombay High Court, along with Calcutta and Madras High Courts, has concurrent jurisdiction with the district judge in exercising powers related to probates and letter of administration. Through this session, we aim to gain a comprehensive understanding of these legal provisions and their procedural nuances. I'm confident that Tejas Sir's expertise and practical knowledge will provide us with immense clarity on these matters. I now request Advocate Tejas Vora to conduct the session.
Good morning, everyone. Dr. Nilima Bharbade, Dr. Varsha Khandenkle, Advocate Patwardhan, Advocate Kanetkar Sahib, and my younger friends. Today we are gathered here to understand a law of succession. We all know that our life is divided in three phases. First phase 1 to 30 age of our life. Second phase is 30 to 60. Third phase is 60 onwards. All my younger friends are in phase 1, age 1 to 30. Here the object of the life is, what about me? I have to study, I have to make my career, then I have to settle in my life. That is 1 to 30. 30 to 60. What about us? Between 30 and 60, you are settled, you have a family members, you have to look after them. So you think, what about us? And after 60, you think, what about after me? Because by that time, you have created the property, assets, family is well settled, you have many relatives, and you have also property. So you will think, what will happen to all my assets and properties? Because human nature is such that anyone who is capable and with the grace of God can create the property, will create the property assets for future generation, and then he will also think that after me how the property will be managed, distributed, because by that time you know what are the relatives to whom you would prefer. Many children are there, with unfortunately with someone you have no good relation, you want to exclude, you want to prefer to someone else. So here the concept of succession comes. Now what is succession? Means we know that everyone creates the property, and after the succession opens at the time of the death. That means when a person dies, the succession law becomes operative, and then it will decide who are the heirs at the time of the death, to whom the property will go. Now there are two kinds of succession: intestate succession and testate succession. Intestate means by operation of law. You don't make any will, then the law gives, because now India is a complex unity in diversity. We have many race, religion, and are there, and many religions are there. We have a civil procedure code uniform for everyone, CRPC. Now new act has also come, so criminal laws are applicable same, but for personal law, adoption, marriage, succession, still we are governed by our personal law. Now here intestate succession, the law will provide who will be your heirs, and everyone knows that justice is a branch of a religion, because we derive our law, concept of law, from Manusmriti and all. So earlier when the religion developed, because we are a civilized society and the rule of law prevails, the civilized society and law and regulations makes the difference between the animal kingdom and human race. So all intestate succession, the law will give the name of the heirs, and there are class 1 heir, class 2 heir, class 3 heirs, and if there are heirs in the class 1, they will take everything, then class 2 will not come. Then similarly, then class 2, there are entries 1 to, if you see the Hindu Succession Act, at the end of the act schedules are given. So section 8 will be for male Hindu, 15 will be the female Hindu, and ultimately the property will go like that as per the intestate succession. Now testate succession is a will. Now what is will? If you see the definition of a will in the Indian Succession Act, will is a legal declaration of intention of a testator in respect of his property which he desires to take into effect after his death. Now and always there is a settled principle of law, because the will creates artificial succession, and without will it will go as per the law. Now first I will deal with the succession certificate, because now succession certificate is obtained when there are only movable property, cash, fixed deposit, shares, securities and everything, no immovable properties are there. Then you have to file petition for succession certificate. Now there are two advantages of filing. Earlier both the madams have said why legal representation is required. Today is the complex world. You have many known relatives, disclosed relatives known to the public, as well as somebody as secret relatives. So tomorrow if you take the representation without knowledge and consent, and despite having knowledge, you obtain some legal representation, tomorrow that person will come, this is the proof, I am the one of the heir as per the law, and so that grant should be revoked or give me my share, because the court doesn't differentiate between the legitimate and illegitimate child and even other relations. We will not go into that. Now the succession certificate serves two purposes. One, description of the property, ownership of the property, and the relatives. Now you all are aware there are two kinds of judgment: judgment in rem and judgment in personam. It's a Latin word, judgment in rem, which is available against the entire world. Means suppose somebody has obtained the legal representation that he was my father and we four are the only heirs, like probate or anything, I will come later on that. Then that is the judgment is available against the entire world. Like insolvency, if somebody is declared insolvent, then that judgment is applicable to the entire world. Nobody can deal with that insolvent. That it is like that. And judgment in personam, between only two persons. Suppose I enter into an agreement with the builder in respect of the flat, there is a dispute, a suit is filed, I won, decree is in my favor, but that judgment only binds me and builder. third party is not concerned. But here, in this law of succession, it is available against the entire world. That now in succession certificate, all the heirs should be cited. Now we have a layman's concept that married daughters are not the heirs, or somebody is not in relation, or has gone to USA for 10 years, it need not be cited. That cannot be done. Anyone can apply for succession certificate, any heir, and he must cite all the heirs, and preferably, because there is no will and only movable property is there. So he will say he will obtain the consent of all the heirs at the time of filing of the succession certificate. Suppose some heirs doesn't say give consent. He says I have a will and entire property goes to me. Then he must go to the court, file probate petition and issue the citation. As far as succession is concerned, then he will all the heirs consent. You will get the succession certificate. But and if you get the succession certificate, ipso facto you will not become owner of all the properties. Then because the dead man cannot enter into an agreement or transfer deed or anything, he can't any signed document, then that succession certificate gets, then that person who obtains the succession certificate, heir, will have to distribute the property in accordance with the law amongst all the heirs. If given consent, or suppose somebody doesn't give consent, then he has to file objection. Then the succession certificate will not be numbered as a suit like it is numbered in the probate petition and letter of administration, but then it will be a succession certificate, but then it will go for trial. The court will ask that person, why you want to oppose the succession certificate? There is no will, and you all heirs are getting equal shares. Then he has to answer the court. Mostly there won't be any answer unless he comes with a will and says that in the will I get entire property, so all other my brothers and sisters are not entitled to get. That is one concept. Then after succession certificate, then ultimately court will decide. Generally when there is a no will, then succession certificate will prevail and all the heirs will get equally. So after getting the succession certificate, the person who gets the succession certificate, technically he becomes trustee of that property on behalf of all the heirs, and then he has to transfer that property equally in accordance with the law with all the heirs, because he step into the shoes of the deceased person, because the deceased person cannot transfer, he cannot sign any document. So all transfer and everything, then bank and everything, they will transfer in favor of that person, and that person has to distribute the property to all the heirs. This is the succession certificate. Now jurisdiction. The succession certificate is always at the place where the deceased had a residence, because the immovable property can anywhere in India. Kolkata, Madras share certificates are there. One company has a registered office in Kolkata, one is in Delhi, but residence of the deceased creates the jurisdiction. So that is the one thing. For Bombay High Court Bombay Court is a district court. Now this Bombay, Calcutta and Madras High Courts are a chartered high court. They are established by the Royal Charter. They have throughout the jurisdiction of India. So any grant which is issued by the Bombay High Court will have effect throughout the India, whether the property is in India or Nagpur, India or Madhya Pradesh, in Maharashtra or Madhya Pradesh or Calcutta. That is a different thing. Now succession certificate, we have done that, it will be implemented by the person. Now second is letter of administration. Now letter of administration are of two kinds: letter of administration alone and letter of administration with will annexed. Now when there is a no will and when there is a immovable property belonging to the deceased, then you have to file letter of administration. You cannot file succession certificate, because the succession certificate only relates to movable properties. So now jurisdiction for letter of administration will be where residence of the deceased as well as part of the property is situate under whose jurisdiction that property is situated under which court. Suppose land is in Bombay and other properties are in Calcutta, then Bombay High Court is a jurisdiction to get the dispose of the letter of administration. The person can file. Now, who can file the letter of administration? Because there is no will and the dead person cannot execute any document. So, for letter of administration, any one heir of the deceased or residual legatee, he has a first right. Means residual legatee who also gets as a one of the heir can file the letter of administration, and if possible he will since there is no will and the property as per the law will go to the all the heirs equally, and this legal representation for immovable property or any property is required for two things. One is the declaration of the legal representatives that we are the only heirs and other thing, and second, the ownership of the property is settled, that it belongs to the deceased and now it will belong to after court grants the legal representation to all the persons who are named in the succession certificate of letter of administration. Now, letter of administration, suppose somebody else, again generally when there is a no will, then all heirs will say yes, we admit no will, will give consent. Either one or two can file letter of administration. But and if somebody objects, then citation has to be served to that person, inviting objection within 14 days. If he doesn't file, if he files the object caveat, that is we call caveat in testamentary. Generally people say objection, but here we say caveat. If within 14 days the caveat is filed, then this petition will be converted into suit and it will go for trial. Now again he can have a defense two things, that I have a will and I get all the properties, other heirs are not entitled to apply for letter of administration, and the court always prevails that will, because will creates artificial succession and the natural succession is as per the law. So preference of the court is let will prevail, because that is the ultimate desire of the deceased. See, when you deal with the testamentary practice, you have to maintain very high moral fiber and with delicate approach and sensitive approach to the matter. The reason you are dealing with the last wishes of the deceased who is not on this earth, and naturally everyone feels no, we must give peace to the departed soul. That is why we have to go as per the will. So if he files the caveat, then it will be converted into suit and that will go for trial. The court will ask that person, why you want to oppose? There is no will. Suppose you have a will, then you file probate petition. One thing you must keep it in mind: will is a piece of paper unless it is probated. Will is a piece of paper unless it is probated. There are many times the people say, no, we have a will, हमने रखा है, कबाट में रखा है. No use. Will becomes legal document only after probate. What is probate? The certificate of genuineness and correctness of a will issued by the High Court or District Court, whatever court. And because now as far as letter of administration is concerned, it will go for trial, and then the court will ask that person who has object to letter of administration, say that why are you objecting? He says, I have a will. You show the will, you file probate petition. First probate petition will be heard, then a letter of administration. If will fails, now will is always, last will is preferred. Suppose somebody has made a will on 1st January and second will is made on 1st February and he died on 1st March. Then the first will be go for trial of 1st February. If it is go through and will is probated, then that earlier will of 1st January ipso facto will go, cancel. But if 1st February will goes, then you have to go for trial of the 1st January will. Then that will have to be proved. If both the will proves, then as per the intestate succession, everyone gets, unless there is some third will or anything. Now letter of administration, suppose person gets, then also he gets a right of administrator. He becomes trustee because he has to administer the property of the deceased. He step into the shoes of the deceased for the purpose of dealing with the property. He has to distribute to all the heirs, whether it is a land, immovable property or movable property, and movable property. So he has to prepare the transfer deed. Now if you see there are relevant section, and it is also mentioned on the grant. Within 6 months you have to administer the property and file report and get the consent of the approval from the court that in this way I have administered the property of the deceased within 6 months. If there is a delay, you have to apply for condonation of delay and file reports and accounts, and you have to for transfer of immovable property. So then administrator will transfer the property by executing transfer deed in favor of the beneficiaries under the letter of administration. So that way the administration of the property will be complete when there is a no will. Now we come to the LA with will. What is LA with will? Then I will go for probate last. When there is a will and executor is not named clearly that I hereby appoint the executor under this will, but by tenor means executor, the word executor is not named, but it is mentioned, I hereby direct Ramesh to distribute this amount to my heirs. Then by tenor he becomes the executor. So that will be the letter of administration with will annexed. Will is there, but executor is not there. So it will be a letter of administration with will annexed, and ultimately the name differs, procedure is same, effect is same, result is same, but the law provides that if there is an executor, you have to go for probate, and if there is no executor name, either by tenor or even if by tenor, nothing is mentioned in the will that is general direction, you will get this, you will get this, but who has to do it? Now the dead person cannot do. So one of the heir or residual legatee will apply for letter of administration with will annexed, and he becomes administrator. But when he becomes administrator, then even after same procedure, consent of all the heirs, if one heir objects, another objects, citation will be served. He files objection to that will, file caveat, then it will go for, it will be again numbered as a suit. It will automatically, department will convert as a suit. Then it will be a letter of administration with will annexed, then it will be a numbered as a suit. And if is non-contested, then letter of administration will be granted to the petitioner. Then again by ipso facto he will not become owner. He has to administer the property as per the direction under the will to all the heirs. Suppose there are 3 flats and one plot is there, then he has said that this plot will go to this flat will go to this person, then he has to prepare the transfer deed. Because see, when you go to the for revenue court or even collector's office, then who will sign on behalf of the dead person? Who has authority? Either executor or administrator. Dead person cannot sign any legal document. Then who will step into the shoes of that person? So administrator will prepare the transfer deed, transfer that property to that person, then he goes for registration. That time he has an authority that this letter of administration was granted to me, and that administrator has transferred this property to me, and then it should be transferred to me because under the will it comes to me. Then he becomes owner. So that way administrator is technically, he must be getting his share, there is no problem because he is one of the heir. But it may happen under the will he does not get anything, but he is an administrator. One more thing, whether when you cite the heir in the petition for succession, letter of administration, all heirs will be entitled to get. But in a will, suppose one son doesn't get anything, but even then you will have to cite. You can't say that he doesn't get under the will, why should I cite him? Because the test is on intestacy, who is entitled to get, you must cite those persons as an heir in the petition. Tomorrow that person should not come and say that I have not been cited. That is the first ground under 263 for revocation of that grant. And your entire time, energy and money will go. The court will say you have not cited him. Whether he gets under the will or doesn't get, that is different. That is the second question. But you must cite all the heirs as per the law. Whether he stays in America or whether he is in Madhya Pradesh or anywhere else. Now that administrator will transfer the property to that person. Now it may happen that he is the heir. He doesn't get under the will, but he can apply, he can become administrator and he will transfer to all the property to all the heirs as by transfer deed. Now we come to the will. Where will, I have already said that what is the will, and now the question is, if an executor is named, then the executor will apply for the probate. Now under the earlier speakers have already dealt with it, that the succession opens at the time of the death, and the executor step into the shoes of a deceased person as if the deceased, and to protect the property, as if the deceased person would have protected his property if he would have not died. But his role is very restricted to the protection of the property. Now under 213 and 214 he can initiate the suit for protection of the property, everything he can do, but subject to conditions of the will and for bona fide purpose. And after probate petition is filed, now one of the heir can be an executor. And now we coming to the will. See, will is a very sacred document. It's like a, you can say Bible or Gita. You can't change the shloka or verses. You can interpret. But the question of interpretation of will comes only after probate is granted. Because will is a piece of paper unless it is probated. So you cannot change or alter any of the clauses of the will. Second thing, of course it must be practiced here also. In Bombay High Court, everywhere there, when you file a probate petition and you have to file original will, then original will is never returned to you. Even if you withdraw the probate petition, will is never returned to you. The reason being, suppose you withdraw the probate petition today and you change the will. It's a very common now. And again you file the probate petition. That means the original will, the intention of the desire or wishes of the testator is gone. So that is why it's a sacred document. So since the High Court is established in 1862, all the wills year-wise they are kept in the strong room. You get with the certified copy of the will, but original will is never returned to anyone even if you withdraw the petition. So that is the very sensitive document, and that document is made a person who is now not on the earth. So and this is the only document which speaks after the death of a person. All other documents speak during the life of the person. I signed this, I was forced to this. Now for a valid will, any person, you can make a will of your own property which belong to you. You can, now you all are aware that the plea of Benami has gone. You can't say this property is mine, though it is in his name, I paid money to him. You can't say take play. Or he cannot say, no, that property belonged to him on paper, but actually monies are mine. That also it can be done. So you can prepare the will of your own property. At the same time, one must keep it in mind that court is not concerned with the contents of the will. It is possible one father will give Taj Mahal and Gateway of India to his son in the will. No problem. Two witnesses will come and say non-contested will. All are agreeable. The other properties are also. Witness will come because now will are of also two types: contested and non-contested. First, I will non-contested. Then I will go on contest because that is a lengthy procedure. So then High Court will certify the will and issue probate. Probate is genuineness of the will. This will is validly executed, and what is the conditions for a valid will? The person should be of sound mind, disposing state of mind, without any coercion or of free volition. He should execute the will, and the witnesses need not read the will. But all three must sign together. It cannot be that a testator will sign today and one witness sign tomorrow and one witness sign day after tomorrow. Because if it is contested and the question, because first will is proved by the attesting witness. First he goes in the witness box because the will is the only document which is to be proved. So first he goes into the box and say that this will was executed by me in our presence, we all three being present yet together, my lord. So that is the question. So, and second thing, when you choose the witnesses, they should be younger to the testator. It may not happen that witness go first and testator survives, then no use of. So that is the one thing you must keep it in mind, and make the will simple, because ultimately, and you can make the will of the property of the person who makes the will. He cannot say that I have given my flat to my wife and I desire that she should give flat to that son, or it cannot be a third party will. And in my opinion, never make a joint will. Many times the people come and say husband and wife, joint property, joint will, because nobody goes simultaneously upstairs. Then you have to apply, you have to submit original will, again then second probate. It makes a complications in day-to-day practice. So I advise, because properties, you make a separate, suppose one flat is there, 50% belongs to, when no shares are mentioned, generally shares are not mentioned, very rarely, 50% belongs to the A and 50% belong to B. A will make will of his 50%, B will make his 50%. No, there won't be, don't make any joint will or anything, it will create practical problem. In theory you can do anything, but in practice it creates a problem. That is my opinion. And all the heirs will have to be cited, whether they get under the will or don't get, but as per the law, and that is called the person who has a caveatable interest. Now this caveatable interest is not defined anywhere in the act. It is a series of judgment, and it is mentioned what is the caveatable interest. Now there is a landmark judgment of Birla versus Lodha, 2008 Supreme Court, page you can see, that all the aspect of this matter was discussed by the Supreme Court, now by two judges. Now matter is referred to third judges, but so far this law is good. Now caveatable interest. On caveatable interest means the simple test. Who has a caveatable interest? If on intestacy, if there is no will, if you are entitled to get something as per the operation of the law, then you have a caveatable interest. Mere creditor cannot have a caveatable interest. Society wherein the flat is situated, and suppose there are arrears of maintenance and the deceased is not paid, the society cannot file caveat in a probate petition, first pay my dues and then you grant the probate. So person who has a caveatable interest, you have to cite everyone. Now and that is as per the personal law of all the persons, because we have a personal law for Hindu, Muslim and Christians and Parsi. as far as Ismailia Khojas are concerned, it is said they live as a Muslim, but I am dealing with one matter, that is why I know. They live as a Muslim but die as a Hindu, because the Hindu law applies to Khoja of succession. Now, and there is also very classic 1937 Muslim personal law has passed, and there is a judgment of Justice Chagla of 47 or exactly. They say if a Ismailia Khoja die as a intestate, then they are governed by Muslim law, and if they make a will, then Hindu law is applicable. Now that matter is going on, that is point apart. So caveatable interest, if you are entitled to get under the law without will you are getting, then you have a caveatable interest. But only the person, third person who is only beneficiary and who is not an heir cannot have a caveatable interest in the matter. He cannot file a caveat that under this will I am getting, so I am entitled to be cited, because his right will accrue only when the will is probated, then executor becomes liable to distribute the property. So mere beneficiaries cannot have caveatable interest, only the heir on intestacy, they will have caveatable interest. Now suppose all gives consent, then there is no problem, probate will be granted to the person executor. The moment probate is granted to the executor, he becomes proving executor. This word is very important, proving executor. What is proving executor? He has proved the will. Now he has an authority to implement the will and as per the directions contained in the will. Now the executor is a personal privilege, confidence put into him by the deceased. So court cannot substitute the executor. Now suppose executor misbehaves, mishandles the property, damage to the property, then there is a provision under Indian Succession Act section 301, removal of executor, that you can exercise, even any beneficiary can exercise even prior to grant of probate, even after grant of probate, because 301 says you can file a petition for removal of the executor, that he is not handling the property in accordance with will and the wishes of the deceased. So once probate is granted, then the proving executor the executors will become proving executors. Now the first thing they have to do, now there are two kinds of property, how they will handle and manage. If there are, because the property has to be realized, everything, money, everything, they have to open a bank account, separate estate of the deceased in the name of the proving executor, because there are many heirs, you have to distribute. So first you have to collect, then you must discharge the debts, liability, government tax, cess, everything. Then after, because the will has to be provided, that first discharge all my debts, liabilities, taxes and everything, then whatever surplus remains. That is why I always say, you mention whatever remains, that 5% means give percentage for distribution. Don't put figure in the will. Suppose you say pay 10 lakhs to my grandchild, and after distribution of debts and liabilities there are only 5 lakhs, then what will happen? So you have to be flexible, and you have, when you draft a will, you have to think of future. Anything can happen. Suppose there are more liabilities or something. Today the market value of your flat is 5 crores, and when you go for selling you get 3 crores. Then how will you distribute the amount as per the direction of the will? So when you draft the will, you must keep it in mind that mention percentage. minor amount is okay, but you should be sure that amount will remain. So proving executor will collect all the amount and everything in that account, then discharge all the liabilities, all expenses legitimate, and including the legal expenses, court fees, everything, that will has to be provided. Then they will go for distribution. Now transfer of immovable property. Now, transfer of immovable property by executor, deceased person cannot transfer the property. So, executor on behalf of the, by virtue of the probate, he has got authority to transfer the property. They have to prepare transfer deed and get it registered with the sub-registrar of assurances. The transfer deed will be in their capacity as the proving executor, and they will transfer in favor of the beneficiary under the will. Now, it may happen that beneficiary, executor are the same persons, because generally we always advise that the beneficiaries who are getting under the will should be made executors, so they have an interest. Because you sometimes you appoint your friend or something, then they will say, why do you involve me in your personal litigation, family litigation? They have no interest in the property and getting probate. It happens for many years, nobody obtains the probate. Now, because, and second thing, why this legal representation is required? Because it clears the title of the property for future generation. Suppose with from the two angle, one angle from the family members and heirs. Suppose you don't obtain the probate, you transfer the property under strength of the will to brother X. Tomorrow, after few years, the son of another brother Y will come and say, I have a share in the property, you have not obtained the consent of my brother, I don't believe you. Then naturally that will create the problem, because it's a judgment in rem. So, when you get the probate of letter of administration, the future generation's claim is cut off, because class 1 heirs are there, then class 2 heir will not come. If son is alive, then grandson will not have a interest in the estate of the grandfather. Son is there. HUF and that is a different, but this is I am talking of general. Now, he will have to prepare the transfer deed. Now, he will sign in two capacity, one as a proving executor, same person will sign as a beneficiary. Then the property will be transferred, then he has to go to collector's office or revenue office, show that transfer deed that this probate was granted by High Court, this is the proving executor has transferred this property in my name, and then you transfer in my name. So, that is one procedure. Now, when I earlier said that father can bequeath Taj Mahal and Gateway of India to his son, probate will be granted everything, but then that son will go to the collector's office and say that this property belongs to my father, he has transferred to me. Collector will say, let it be on the paper, this property card, Government of India is there, it does not belong to your father, so forget it. That is the one thing. So, we have to be very sensitive, practical regarding drafting of the will and implications. So, this property will be transferred by proving executors, then distribution, and again in a probate also within 6 months you have to give report to the High Court regarding how you have implemented the probate. Now, one thing, the power and authorities of executors derive from the will. They cannot travel beyond the authority given under the will. They are limited to that. If there is no power to sell, then they cannot sell. If there is they say, the testator has said, transfer this property to my son, he has to transfer. He has to protect. So, he can't sell the property. He can protect the property because he is a trustee. They step into the shoes of the deceased. Now, in a probate petition, contested. One son says that I am contesting, I don't believe this will, the signature of the common ground signature is forged, my father was compelled to that, or that time when the will was signed, my father was not in Bombay or anything. Then he has to file caveat within 14 days, probate petition will be converted into the suit and the matter will go for trial. When matter goes for trial, then caveat is filed, affidavit in support is filed, it is converted into suit. You take it that this affidavit and caveat is written statement. Now there cannot be any answer to further affidavit or anything to the caveat. Then first thing will be issues will be framed. Under issues will be framed, because when you are for the caveator, you have to be very careful, because unless you prove the allegations on which you are challenging the will, if you are not able to prove, then your caveat will be dismissed. सिर्फ हवा में बात करने से नहीं चलेगा. There is a saying ना, कानून सबूत मांगता है. So that is why you have to show what proof you have that on the day when the will was signed, father was not in was in hospital, he was in coma, whatever ground you say, or he was not in town, he could not have signed, and you have to show admitted signatures. So then court will decide the issues, on what issues the will is being challenged. After issues are framed, there are 3 stages of trial: documentation, evidence, and arguments. Now documentation, first I have said that attesting witness has to prove that we hope that both the attesting witness are alive. If matter is contested, then you have to file affidavit of both the attesting witness. But you have to ensure, you have to first prepare and understand them, you have to take instructions with them, that there should not be any contradiction between 2 attesting witness, even not only in the paper but also in cross examination, because nowadays in court we have a very judges have no time, so they appoint commissioner, and the recording of the evidence is taken by a commissioner. They are comparatively young lawyers who are on the panel, they are appointed as a commissioner, and then he has to record the evidence. Objection comes, then that will be decided by the court. So evidence, first examination in chief will come for attesting witness. That person cannot file any affidavit. So will be proved by attesting witness. First his affidavit will be there. Then he will go in the box and other side will cross examine. First attesting witness has to be cross examined to prove the will. In the cross he will be asked various questions. He should maintain what is a valid will. He was of free volition, sound mind, disposing state of mind, without any force or fear, and he has made the will in our presence, and we all 3 were present together. That is the crux of the matter. He has to stick to this, and naturally this is the truth, because that is why I said in the beginning, ensure that all the 3 persons are there at the same time, testator and 2 attesting witness, who should be younger to that attesting witness. And second thing, attesting witness should not be relative of any of the beneficiaries. Then the question of undue influence comes. Always take third party, friends, neighbors, or known to the family as a attesting witness. Family doctor will be there, certificate. If will is to be registered, then the registration doctor certificate is must. But if will is not registered, then certificate is optional. And second thing, if you have registered the will, then if you change the will, then you have to again get it registered and get that cancelled, and you have to mention that that will is registered. Personally speaking, I am not in favor of codicil. It creates more confusion and misunderstanding, and the change of date, everything. Better advice to make new will. Codicil will be a correction to the will, then both document has to be tallied, same witness is not there, again there is a practical difficulties. So avoid codicil, that is my opinion. So now attesting witness and everything, and one thing, when one attesting witness is being cross-examined, another witness should not be remain present at that time, neither plaintiff or attesting witness. They should be, otherwise that amounts to compromising evidence and your evidence goes. So one attesting witness is done. Suppose second is not available, no problem. Available, then again go. But there should not be contradiction in evidence of both the attesting witness. After attesting witness is done, then the propounder of the will, means executor, who has filed the petition, he goes into the box. Technically speaking, his role is not on the contents of the will, because it may be happen that when will is prepared, he may not be present, because the testator will prepare the will in the basis of the in the presence of the testator, seal in the cover and give it to the executor that I have named you in the executor, and after my death open this cover and file petition. So, but even then, his role is very crucial. What common question? Suppose there is a delay of 1 year, 2 years, 3 years in filing the probate petition. Then naturally he has to explain, because the caveator will not leave him like that, because he has to disapprove the will. And suppose he is propounding another will, then he has to file probate petition. He can't keep it in his pocket, the second will, and say, I have a second will, I have not applied for probate, but I am challenging you. Then ultimately, then you can tell the court that unless he files probate petition, he cannot take this ground. So second witness and probate petition, then propounder will come. Why delay? Why did you not file earlier? Who gave you the will? All these questions will come. Then he has to, so as far as attesting witness, either one or two, and second thing, propounder and petitioner of the will. Now plaintiff's case is over. Who is propounding the will? He has proved. He has to prove the will under section 63 and 69 and 52 Indian Succession and Indian Evidence Act, that will was signed by the deceased in our presence, we all being together, and he was of sound mind, and that is why he has signed in our presence. That execution of the will should be proved by all these two persons, attesting witness. Propounder doesn't come in the. Now the question of the caveator will come. Then again the documentation will come. He has already filed the caveat, but now he has to file affidavit of evidence. Now he has to justify. It may happen. And second thing, one thing, whenever you file caveat in any petition for challenging the will, always take inspection and then file caveat. Never file caveat without taking inspection of the original will. I personally go to department when matter comes to me for filing caveat, because I have to argue, I have to compare the original will along with my client, and then always when you take the inspection of the original will, notice is given to the other side, and in the presence of officer, the original will is brought from the safe custody and is given to you. You are not supposed to keep the pen also, because you have to just look, turn the pages, see, and make note in your note with the pencil. It's a very sensitive document. So never file caveat without taking inspection of the will, original will. Then only you come to know. This is a High Court original style rule number 384. If a person who was present at that time, who has seen all three persons signing, but he has not signed the will, then that person can make affidavit that I was present when testator and two other witnesses signed in my presence in one of our matter. Both the witnesses were dead, and the will was of father-in-law, and the daughter-in-law was married only 3 months ago when the will was executed. Then we asked her who were in the home. She said, I was there. What was the reason you were at home when this will was signed? So my father-in-law has told me that I am executing the will today. My 2 friends are coming, so you have to make tea for them. So I was in the home, and when I go for offer them tea, I saw them all 3 were signing. That affidavit help us under Rule 384 of High Court original side. All 3 persons are dead. Who will prove the document? Some witness has to be there. Now, the will is genuine, not only one person can say who is not here. So, we have to prove this document through witnesses and circumstances. So that is why we proved the will and we got the probate. Now, coming to earlier incident. I saw endorsement between 1:30 and 2:30. Both the witnesses are dead, 1969, there is no question. Then what happened? One witness came and he said that the testator who was staying at Dhanu came to my residence as a Valkeshwar. Then we all went to Fort Office of Advocate. Then the will was prepared therein, and it was signed in my presence. Now, will was signed not in the lawyer's office. It was signed before the registrar. That endorsement was there. So when I cross-examined, I put all the, I have taken the inspection of that original will and that endorsement. I am explaining you so that how practical knowledge will help you and how to approach the problem. Then I asked what time that Purushottam Bhai came to your house at Valkeshwar. This time, what did you do that? We had a lunch. Then we went to that advocate's office in Fort. What time did you reach? 1 o'clock. Okay. Then how much time it took to prepare the will and everything? That he said 3 hours or anything. Then what time they went for registration? 3:30 from lawyer's office to Old Custom House. I said, why did you not go? No, I had some work, so I left the office. Now, on the original will, the endorsement is between 1:30 to 2:30. Now, if his own evidence, he says that up to 3:30 we all were in. Then I asked him, who were present? He said no, that the Purushottam Bhai who made the will and all solicitors, advocates, myself were present in the office at 3. By 3:30 I left. I said, till then they were in the office? Yes, they were in the office. So now in argument, I have to show only one thing. He is lying. It's a giving false evidence. He was not present. He has been brought up. Because the endorsement of the registrar speaks between 1:30 and 2:30, and up to 3:30 you are in the advocate's office. How it is possible? Either registrar is false, making false entry, or your witness is making false entry. So this is to be noted. Now, then caveator has to prove that I am making these allegations, I am producing, you have to file compilation of documents, original, then our documents are not admitted, anything that is done before the court, not before the commissioner. And then he will say that this is the medical certificate, he was in coma in the hospital. how can he sign? So again, then the petitioner will cross-examine and try to prove, to demolish his case. Okay, whatever is is telling by you is not correct. He was in full sense, he was his free volition, and he has signed this document in our presence of witness, and they have said. And second thing, never ask question to the caveator or caveator, what is the proof you have got on this allegation? Because the moment he gives the proof, it becomes oral evidence against you. Because something is there, in spite of the written documents, still the oral evidence is given more than equal weightage by our judicial system. Because on paper you can lie, but on the face when you speak, it becomes very difficult to lie. And that is why the importance of the oral evidence is still weightage in our judicial system. So then ultimately the evidence and everything is over, then commissioner will make a report, and then it will go for arguments. And then judge will consider all pros and cons, and ultimately he will say whether will is proved or not. If will is proved, probate will be issued, then of course any person agreed by any order can go in appeal, and ultimately Supreme Court is there. But this is the procedure. But the burden to prove the allegation, and that is why I said, for caveator your case is very difficult, because you come to know about the will later on. You don't know what has transpired on that day. Unless you are 100% sure with the evidence that day will could not have been signed by the deceased. If you are 100% sure, and if you are able to prove, then only you can succeed. Otherwise, never make any allegation for the sake of making allegations, objection, and ultimately, if matter is settled in a probate petition, then the first terms and conditions of the consent term, the probate has to be issued as per the will, and then consent terms are annexed to that probate is issued, because you can't alter or dilute the clauses of the will. Probate as it is, will as it is, but then parties will exchange inter se, that in will I get this flat, but I want this flat, so I give you this, but probate will remain as it is. That is the law. You can't alter the clauses of the will, dilute anything, but it has to be, you can settle. You can't, many times it's a money issue only, but you can't write in the consent terms that I have received X amount, so I am withdrawing my objection. Because the judge will say that if you get money, then will is genuine. If you don't get money, then will is not correct. So you have to be very cautious, and second thing, you have to approach the court with clean hands. Don't suppress anything. And these testamentary matters are very sensitive matters, and the court is of caution, not suspicious, because you are dealing with some otherwise this concept would not have come. Why in today's world we don't respect living person, then what is the use of respecting the dead person's wishes? But no, law says forget living person, let them fight, let them do whatever they do, but the dead person's wishes is a paramount, it has to be respected, and that is why this law of succession has come into the force. Any questions, anyone?
Hello, yeah. Sir, summary nature of proceedings in succession certificate and a much more detailed proceedings in probate and letters of administration. So how is it different? We say succession certificate is a summary proceeding.
Now see.
What is the difference between it?
If any matter is not contested or challenged, then all matters become summary process. For succession, if contested, letter of administration is contested, probate is contested, then it becomes long cause. But in summary proceedings, even if not contested, because when there is a no will and there are no immovable properties, then succession certificate. Actually nowadays the time is being taken same for all the proceedings. Summary in the proceedings, because once objection comes, then court has to hear both the parties. Then there cannot be a it's like that our summary suit, it's not like that admitted liabilities or any, it doesn't come. The moment objection comes, either first court has to decide whether objection is valid or not. Then in summary, succession certificate, the objections are filed. In letter of administration, probate, LA with will, caveat is filed. But there cannot be a summary procedure, because ultimately you are dealing with the legal representation to the heirs of the deceased as well as the property owned by the deceased. So in my opinion, there cannot be any summary proceeding in contested matter. Non-contested, there is no problem. It goes smoothly without any contest and everybody will be happy earlier. But contested, then the suit, then forget minimum 5 years, 10 years. Yes?
In case when both the witnesses and testator of course is not there and both witnesses are also not alive, in that case will the court verify the signatures of testator as well as the witnesses when third person or third eye witness is not present or available?
No.
So how is it verified? The
yes.
will is probated.
Now see, there is a provision. I said earlier, 384 rule, High Court original side rule, and also Indian Evidence Act.
Yeah.
How document is to be proved?
Experts, yeah.
You have to get some witnesses. Mere comparison of signature on paper will not solve your problem, and court will not accept that. Because one thing, if matter is non-contested, then the matter doesn't go to the court or the judge, except heirship goes to the judge. In Bombay High Court, the heirship is issued by the High Court judge because it's a district court. But letter of administration, succession certificate, LA with will, if non-contested, it is done on the departmental, all checking and everything is done. Even Rule 384 affidavit is filed and it is accepted. But if contested, then the caveator will cross-examine that witness under 384. How can you prove that you were present? What is the proof of anything? So you have to be very careful. Handwriting expert, everything, but ultimately it is a discretion of the court. Court is not bound by anything. I'll say conscience of the court should be satisfied that will is genuine and it is properly executed and the testator was of sound mind at the time of execution of the will and when he signed the will. So mere comparison of the signature and everything is not. No, testator is gone. No, but he will say, no, I verify their signature because I was present and in my presence they have signed. That is why the third person. I explain you, third person, not witnesses. He said, I was present to the incident. There is always one person to give evidence to that. You have to find out.
Take example, both the witnesses, attesting witnesses are there. But a son or a brother of one of the attesting witness, that you can try, you can say, Because wording of section 7, who is accustomed with the signature. Take example. These two persons are particular have a correspondence, having a signature. He can also come and say that I identify the signature. Am I right? Section 67 to take that way, who can identify the signature. It's not necessary. So many cases it may happen. Witnesses have gone, everybody has gone. I was saying that well. In one case matter happened. To my will in that particular case, one of the attesting witness has already gone. Second attesting witness was residing at Nashik, suffering from paralysis and etc. etc. Question arose how to prove it. He was not able to speak it. Then in his presence, his son, because question arose whether his signature of a particular testator or not, because you are on the point of signature of a testator. So therefore I pointed out, if I remember, there is one judgment also which says in that case, the person who identifies the signature of that attesting witness or a testator, he is also a competent witness. That is what the practice we have followed in that, and we find.
And generally that 30 years old documents
Then
not
that is another
applicable to
aspect.
the
That is as per the old section 90.
Old,
We say the document is more than 30 years old.
it has to be.
But that is only applicable in case of original document.
Original.
Not in respect of
Will.
secondary evidence in that or a will. Yes, but it was,
Yeah.
sorry, but I
No,
wanted
no,
to.
no. You are
Sir
saying.
said that you have to satisfy the conscience of the
Yes, conscience of
If
it.
the will
So signature is identified by somebody else, then nothing happens in that case.
Somebody has to identify.
Somebody has to identify the signature.
satisfy the
And,
Yes, satisfy the.
and the procedure, how he can identify.
Now he can say.
He can. I am familiar to signature.
Yes, take example.
This is my father's signature.
Yes, take example, he says, testator, grandson also that. Even grandson comes in that way, I have seen the signature of my Abaji. I identify the signature of my Abba. He can very well say. Or any friend can come, I am always having a transaction with that particular grandfather in that particular person. I could see that very signature, and therefore I know that this is the signature of my grandfather. That also can, provided what you say is correct, it has to be identified by somebody else. But that can be done. Merely because witness is not there or merely nobody is
No,
there,
it
that
is-
cannot be the case in that.
Absolutely. And that is why one thing, if will is there, you have to approach the court for probate, legal representation at earliest. This is the only litigation, you don't wait other side to come. Other side files the letter of administration, and which after 6 months you come with a will, court will become suspicious. Why were you waiting? If you knew the death of a person, if you have a will, why did you wait? Naturally the court will think that it may be a fabricated document, afterthought. So you have to be very cautious in this kind of litigation. Thank you.
So, my name is Vijeta Kulkarni, and being a third year BALLB law student, this concept is quite new to me, and I'm confused in a concept that in section 307, as stated by ma'am, it was regarding the power to dispose of the property by the executor, and ma'am said that a property is bequeathed by will to A and executor sells it, then the sale is void. But as stated by you, in the transfer of immovable property by executor, if it is said to transfer the property to X by a will, and if then the executor can't sell the property but only transfer it. So I'm confused whether executor can sell the property or not sell the property.
In my opinion, he should not deal with the property because his authority derives from the will. If will doesn't give power, that is my interpretation. If will doesn't give power him to sell, but he says you transfer the property, then he has to transfer the property as a proving executor. Even during the pendency of the probate petition also he cannot transfer because he has no authority. He can protect the property, but to deal with the property, so power is given, but in my opinion it should not be exercised.
Okay, sir. Thank you.
Hello. So if a original will is missing and the will was registered, can a duplicate will be the copy received from the sub-registrar's office be used for probate?
Yes, absolutely, absolutely no problem.
Thank you everyone for your thoughtful questions and active participation. I would like to extend my heartfelt thanks to Tejas sir for sharing his vast knowledge and expertise with us today. Your practical insights have been invaluable and we are truly grateful for your time and effort. It's been an absolute privilege to learn from you. We will now break for lunch, which is being served in front of the principal's office on first floor. Please reconvene by 1:30 p.m. for our third session of the day. Thank you.